Now let's start our new chapter. The name of chapter is Law of Torts. Now, what does the word tort means? Tort means a civil wrong. Okay, civil wrong, a thing that you should not do, any person should not do. It is the breach of legal duty or infringement of legal rights which give rise to claim of damages. Tort is basically breach of a legal duty. Legal duty means what any citizen of the country should perform the duty. Okay, that is known as legal duty. And if you are breaching that legal duty, or if you are breaking any rights of other person, then this is known as tort. Tort is a type of civil wrong. As it is breach of legal duty, there is no liability unless law recognizes that duty exists. Because tort is a breach of legal duty. So when the law will recognize that okay, there was a legal duty of a person to perform this, and he didn't perform that, only then claim of the damages will arise. Okay, but if there is no legal duty in that scenario, then the person will not be liable for tortious action. According to law, tort case can be filed within 6 years, and in case of personal injury period, it is reduced to 3 years. So limitation period of the tort is 6 years, and if the tort is regarding the personal injury, then it will be 3 years. Okay, a contractual relation doesn't need to exist for claim of the tort to be successful. For example, claim for personal injury in road accident. So in the last chapter, contract law chapter, we talked about the cases in which there is a contract between two parties, right? And one party can put up the claim for damages or sue the other party, okay? But in case of tort, there is no need of a contractual relation. Like for example, if you are walking on the side of the road and someone hits you, and because of that you suffered an injury. Now there was no contract between you and that person, right? But still, you can put up the claim for damages, for tort on that person. So that is known as tort. Tort is basically a type of civil wrong. Like for example, if you go to a restaurant and it is a restaurant duty to provide you with a standard service, right? The place should be clean, the food should be clean. If they do not do that, then they have committed tort. You went to a doctor and the doctor didn't check you on the spot, and because of that your injury got worse. Now doctor, if your case was if your case was an emergency case, he should have checked you, but he didn't. He committed tort. But tort is basically a type of civil wrong. You are, let's say some neighbor came to your house and he is playing the music on loudspeaker and he is disturbing you, he's disturbing you, then you can put up the claim for tort on him as well. Why? Because he is doing civil wrong. Okay. Main elements of tort. Following condition must be met in order to be successful in action of the tort. So if you want to be successful in an action of the tort, these conditions must be met. First, there must be an act or omission by defendant. Defendant means the party who is defending himself. Claimant means the party who is, claiming to be innocent or claiming that other party did bad to him. Now, the first condition is there must be an act or omission by the defendant. Defendant did something or he did not do something, which must have directly caused loss to the claimant. And because of that, because either from the act of the defendant or omission of the act by the defendant, claimant suffered some kind of loss. Okay. Court must be able to establish legal liability, and because of that loss, a court can establish a legal liability that the defendant party did something that has affected the claimant party, and because of that he is entitled to pay this much amount as a compensation to the claimant party. So court must be able to establish legal liability. The losses, they should be not too remote. Okay, too remote losses are not recoverable. We have talked about this concept in the last chapter as well. So three conditions must be met in order to be successful in action of the tort. There must be an act or omission by the defendant. Defendant should have done something, but he didn't. Like for example, if there was a person who suffered an injury, and if another person is, he's watching that person suffering injury in front of his eyes, he should take reasonable actions. Like for example, he should call an ambulance. And if he has his own vehicle, he should put up the injured person in his vehicle and take him to the hospital. He should do this. It is his legal duty, but he didn't. Omission. And because of that, the party who was already injured suffered more injury. Okay. So this caused the loss to the claimant, and court must be able to establish legal liability that okay, because of this act, this is the amount that he should compensate to the innocent party. Okay. So for the successful action of the tort, these three conditions need to be met. Tort of negligence. Now, the one thing is that there is a legal duty to do something, right? That is, and if you didn't do that, that is your tort, right? Now tort are of different types. The first one is tort of negligence. What does the word negligence means? Negligence means carelessness, that you were careless at that time. Negligence is a breach of legal duty to take care which result in damages to another. Negligence means that there was a legal duty of a person to take care of another person, but that person breached that duty. And because of that, the other party suffered damages. That is known as negligence. That you were negligent at that time. Okay. In order for an action in negligence to be succeeded, claimant have to prove three things. Three things claimant have to prove. Claimant have to prove these three things in order to be successful in an action for tort of negligence. First, duty of care was owed to him by the defendant. The first thing is he should prove that the defendant owed him the duty of care. Okay. For example, if you went to a park, okay, you went to a park, and in those park there are poisonous berries, that are there in the park, and if someone eats them, he can even suffer the death, because of the poison. Now, the duty of the care is owed to the claimant by defendant. Anyone who is going to the park owner, it is the duty of the park owner take reasonable actions, for preventing others to go close to the poisonous berries. Like, for example, he can put up the board here and write that this is the poisonous berries, you should not eat them. But he should cover that area in which there are poisonous berries. He should. So in this case, the park owners owe duty to the claimant. Okay, claimant basically means anyone who is going to the park. Defendant breached that duty. They breached that duty. They didn't put any signboard. They didn't cover that area, so that that area was safe and nobody could enter that. As a result of that breach, loss has been suffered, and because of their breach of the duty of care, the innocent party suffered the loss. So, in order to be successful in an action for tort of negligence, you have to prove three things: claimant, innocent party, or the claimant. Duty of the care was owed to him by the defendant, that the claimant owed some duty of care from defendant. Defendant breached that duty, and because of the breach of the duty by the defendant, claimant has suffered loss. Okay. Duty of care basically means that duty to take reasonable care not to cause foreseeable harm to others. If you are saying that, because of my act, the other person can suffer some harm, so it is my duty to take reasonable care that other person do not suffer the harm. That is duty of care. Okay. Now let's understand this tort of negligence concept in detail. There are now, what is duty of care? Duty of care is, I told you, there's a duty to take reasonable care not to cause foreseeable harm to others. Now, in what situations duty of care arises? The first one is neighbor principle. A person who owes a duty of care towards his neighbor. Okay. A person owes a duty of care towards his neighbor. It means that every person owes duty of care, which means every person has to show some reasonable care so that other person could not get harmed towards his neighbor. Okay. So every person owes a duty of care towards his neighbor. Now, what does the neighbor mean? Neighbor does not mean in this case that, the person who is living right behind your house, right beside your house is who is your neighbor. No. Neighbor is a person who is affected by our act, or anyone whom we can reasonably contemplate that he will be affected by our acts. Okay. Neighbor is any person that I knew that because of my act, this person can suffer injury. That person will be neighbor. Okay. Or whom we can reasonably contemplate that he will be affected by our acts. Reasonably, the one is that, you know that this person can be directly affected by my acts. Reasonably contemplate means that, in my back of the mind, I know that, because of my act, this person can also suffer some kind of loss. Reasonably contemplate means, I can contemplate in back of the mind. I have that thing that, yes, this person can also suffer loss. Okay. So any person who is affected by our act directly, or whom we can reasonably contemplate, that person will be my neighbor, and I owe duty of care to my neighbor. I owe duty of care to my neighbor. Now, there is a case here. Mrs. D went to a cafe with a friend. The friend bought her bottle of ginger beer, which Mrs. D drank. She then discovered that there was a decomposed snail in the bottom of the opaque bottle. Miss D found this sight so upsetting that she suffered physical illness. She sued the manufacturer, claiming that they were under a duty to see that such outside bodies did not get into the ginger beer. So there was a lady, Mrs. D. She went to a cafe with a friend. And when she was drinking a beer, obviously when she was drinking a beer, she could not see what is, on the bottom of the bottle. When she drank all this, in the bottom, she saw there was a decomposed insect, decomposed snail. And she found this sight so upsetting, it was so upsetting that she suffered physical illness. And she sued the manufacturer of the ginger beer, okay, claiming that it was their duty to see that that outside bodies do not enter into ginger beer. Now try to understand that there is no contract, right? There is no contract between Mrs. D and the manufacturer, but the manufacturer, now the court job is to establish that whether the manufacturer owes the duty of the care or not, okay? And if he owes the duty of the care, then Mrs. D is entitled to get the compensation. There is no contract here, right? There is no contract between them. Now, what did the court said? There was a duty on behalf of the manufacturer to take reasonable care in their manufacture of their products. The manufacturer owes a duty to the consumer to take reasonable care to prevent injury. Mrs. D was successful in his claim because the court says that every consumer is a neighbor of manufacturer, right? Every consumer is a neighbor of manufacturer. The manufacturer knows that consumer are going to use our products, so they are going to be affected by our act. So every manufacturer owes a duty to its consumer to take reasonable care so they could not suffer any harm. Okay. So the neighbor principle states that if because of my act the other party is suffering, then the other party is my neighbor, and I owe the duty of care towards him. Okay, I owe the duty of the care towards him. Duty of care is applied to the nervous shocks when there is sufficient proximity that shock was suffered by someone within reasonable range of a harm. Now, what does this mean? That if because of an act of a person, the other party suffered some nervous shock, okay, some nervous shock, like psychiatric injury or nervous shocks, then I also, then I will be liable because I owe duty of care to him as well. The duty of care is owed to that person who I knew that who is in my reasonable contemplation, that that person can suffer from my act. Okay, so duty of the care is applied to the nervous shocks when there is sufficient proximity. Sufficient proximity is necessary, that there must be a close relationship between the act of a person and my psychiatric injury. Okay, there must be a close relation. Okay, if there is no close relation, then anyone can claim that because of this person acts, I saw his act on mobile phone, and when I watched his act, I suffered psychiatric injury. Anyone can put up the claim for tort, but it does not work like that. There must be a close relation between the act and nervous shock. The shock was suffered by someone within reasonable range of harm. Okay, so the shock cause of my act, someone who was in reasonable range, he or she suffered the shock. Okay, now let's understand this with the case. A motorcyclist was killed in a road accident for which he was responsible. A pregnant woman who got off a tram near the scene of the accident claimed that when she got to the scene of the accident, she saw blood on the road and as a result suffered shock, which put her into premature labor, which resulted in the loss of her baby. She subsequently brought a claim in relation to the nervous shock and the resulting loss. So there was a motorcyclist, who was obviously on the road, and because of his mistake, there was a road accident, and in which and for the road accident he was responsible. Okay, now there was a lady who was not on the road at that time. Uh, she was she got off the tram, or the railway, and when she went up toward the roadside, she saw blood, and because of watching that blood, she suffered shock, which put him she was pregnant, which put her into the premature labor, and she lost her baby. So she put a claim for the loss of her baby on the motorcyclist. Okay, on the representative of the motorcyclist, because motorcyclist himself was killed. Okay, family representatives. Now, what did the court said? The House of Lord held that motorcyclist did not owe a duty of care to the pregnant woman, as she was not deemed to be foreseeable victim. She was not present at the scene of the accident. She arrived after the accident occurred. So the court said that there was no sufficient proximity. Why? Because the motorcyclist, if let's say if the motorcyclist or if someone is driving on the road, and if there's an accident occur, then the person who watches the accident, himself, who is on that scene, he can suffer a nervous shock, and that is closely related to the accident, right? But any person, who has not watched the scene, who came after the, accident was done, and, just, and afterwards, he saw the blood, then he is not in a sufficient proximity. You don't owe duty of care to that person. So similar was in this case, that the lady was not there at the time of the incident. She did not viewed the incident live. She came afterwards, and because of that, the court said there was no sufficient proximity. So the motorcyclist did not owe any duty of care to her. So his family representatives are not entitled to pay you, to pay her any compensation. If she watched the scene herself, then there was a sufficient proximity, and because of watching the scene, she got nervous shock, and she went into premature labor and lost her baby. Then she would have claimed that, okay. But in this case, there was no close relation, so she could not, okay. So the duty of care is owed in case of the nervous shock to only those who are in sufficient proximity, who are in close relation. So number one point that we studied, that we owe duty of care to our neighbor. Number two, in case of nervous shocks, we owe the duty of the care to any person who is in sufficient proximity, reasonable range of harm. The third one, duty of care is owed to secondary victim as well. Your, now, now, what does the secondary victim means? A secondary victim is someone whose personal safety is not threatened, but who suffers psychiatric injury as a result of fear of other safety or trauma of witnessing a harrowing event. Harrowing event means a very sad, very tragic event. Okay. Now, there's another duty of care that a law establishes is to the secondary victim. Secondary victim means any person who himself is not threatened by an act of someone, but because of an act of someone, he suffered psychiatric injury. Why? Because, because of that act of a person, his family member, let's say he was injured, or for the worst case, he died. So because of the fear of other safety, and because of watching something very traumatic, tragic, he suffered injury, psychiatric injury, then that person is a secondary victim. Like for example, like let's say a road accident case, a person who himself has watched that road accident live, then that person will be he will be primary victim. Okay. Secondary victim will be home person. Let's say there was an accident, and because of that a person got killed, a man got killed. Okay. Or let's say a boy got killed. Now his mother or his father, they were not there, they did not witness this scene live themselves. Okay. But what happened was that, when they when they heard the sound, they got out of the car and they saw that, their son got died. Their son was died, or their son, you know, by watching their son dead, they suffered psychiatric injury. Okay, they suffered psychiatric injury because they witnessed, a tragic event. Okay, so such a person will be a secondary victim. Okay, in order to be successful in secondary victim claim, following conditions must be met. So if you want to be successful in the secondary victim claim, these conditions must be met. Victim must have close relation with injured or dead person. Now this first condition was not there in the pregnant woman case, right? Because that person, a motorcyclist who died, you know, he was not his relative, or not his friend, right? So the first condition, if you want to be successful in the secondary victim claim, victim must have close relation with injured or dead person. Like I gave an example that, due to an accident, a son died. Okay, a boy died, and his parents, they were not watching the scene, but when they heard the voice, they got out of the car and they saw their child was dead. Okay, so they had a close relation, right? They must be present at an accident or on the scene in immediate aftermath. Either they should be present at the time of the accident, or just after the accident happened, they were there. Okay, they watched that scene. Okay, so that was also, in this case, the example I gave you. Psychiatric injury must have been caused by direct perception of the accident or immediate aftermath, and they suffered psychiatric injury due to that reason. Okay, like if someone is already psychiatric ill, and then we cannot say that, that he suffered injury because of that, because he already had some psychiatric disorders, right? So these three claims must be met. Okay, these three claims must be met. The point here to try to understand, you need to understand, is that, anyone can claim that, we are secondary victim. That is why these conditions are set out, because, let's say if someone if someone dies in a road accident, and after 6 7 hours a person came to that scene of accident, and when he got there, and when he saw that, people are there, everyone, the place is crowded, and he tried to remember, that this happened to my, let's say, my close relative, and because of that he suffered psychiatric injury, then that is not a secondary victim claim. You must need to be present there at the time of the accident or just immediately after that or in just immediate aftermath. Okay, it is not like that, you go to that place after 2 3 months and by just memorizing or by remembering that scene you got psychiatric injury. It does not work like that. Okay, so for secondary victim claim these three conditions need to be met. Now there is a case here, a very interesting case. 1998, the claimants were police constables on duty for maintaining law and order during a football match in April 1989 at Hillsborough Stadium. Okay, so there was a football match that was going on, and the police constables were there on the duty. As a result of overcrowding and stampede, 95 people died and hundreds of others sustained injuries. So, because of the overcrowding and there was a stampede, and because of the stampede, 95 people died. 95 people died and many sustained injuries. The policemen on the duty, the constables who were on the duty, including the claimants, claimant means, the one who has put up the claim, had to tend to the victims for whom many of them suffered post traumatic stress disorder. Okay, four of them were on duty at the stadium, and fifth one was responsible for stripping bodies and completing casualty found at hospital. Resultantly, they claimed compensation for their psychiatric injury from the police department. Five constables were on duty in a football match. Now, in the football match, during the match, there was an overcrowding, and because of that, there was a stampede, and 95 people died, and many sustained injuries. The policemen who were on the duty, now there it was their job to attend all the victims, and four of them were there on the duty at the stadium. You know, who watched this all tragic event in front of their eyes, and fifth one was responsible for stripping bodies and completing casualty form at hospital. So they suffered psychiatric illness, post-traumatic stress disorder. So they put up the claim on the police department that because of watching that harrowing event, tragic event, we have suffered psychiatric illness, so we are entitled to compensation. Now here the court need to prove that whether they were secondary victim or not. Okay, so they were not secondary victim, right? Because they did not had any relation of love and affection, or they did not have any close relation with the one who died or with the one who suffered the injuries, right? So they did not had any close relation with that, any relation of love and affection. They were not secondary victim, and if they were not secondary victim, they are not entitled to get the compensation. Okay, so for in order to be successful in the secondary victim claim, number one thing is there must be a close relation with the party who has suffered the injury. Number two, you were there at the scene of, at the incident scene or just immediately after that. And because of watching, that harrowing event, you suffered an injury. Okay. So the second and third conditions were there in this case, but first condition was not. The police constables, they did not had any relation with the one who suffered the injury or the one who died. So they were not entitled to the compensation because they were not secondary victim. Economic financial loss. Now, which loss can you recover with respect of tort? Let's say, for example, someone uh, suffered tort, and someone did civil wrong, and because of that, you suffered injury, you suffered losses. Okay. Now, losses are categorized into two things: economic loss and financial loss. Okay. Economic loss action could be taken if physical damage was suffered. Obviously, if physical damage was suffered, you can take an action. In case of pure economic loss, law doesn't recognize liability. Consequential economic loss is recoverable. Okay. Now there are two types of losses, pure losses and consequential losses. Pure losses and consequential losses. Pure economic losses are monetary losses which is unconnected to physical injury to the person or damage to other party. So the loss that is not directly connected with the act of the other party, that is known as pure economic loss. Okay, like for example, if someone committed civil wrong and because of that you suffered injury, now that you suffered loss, that loss which is not directly connected with that person's act, that is known as pure economic loss. Okay, while the consequential economic loss is the one that is connected to the injury, loss connected to the physical injury, and the consequential economic loss is recoverable. Okay, now let's understand these 2 points with this interesting case here. Spartan Steels and Alloy Limited had a steel factory which obtained its electricity by direct cable from the power station. Martin and Co. were doing work on the ground with an excavator and negligently damaged the cable. As a consequence, the factory was deprived of electricity for 15 hours, which has caused physical damage to the factory's furnaces and metal, lost profit on the damaged metal, and lost profit on the metal that was not melted during the time the electricity was off. Spartan Steel claimed all three heads of damages. So there was a steel factory who are getting their electricity from a power station, and in that power station, there were some contractors. They were doing some maintenance work, and while doing the maintenance work, they negligently damaged the cable, and because of damage of the cable, the electricity went off in a factory for 15 hours. Okay, 15 hours there was no electricity. Because of that, there was a physical damage to the factory's furnace and metal. One thing is, that physically that furnace and metal got damaged, lost profit on the damaged metal. Now, the metal on which they were doing working, because of no electricity, that metal got damaged. And if that metal got damaged, they could not, they cannot not sell that, right? They cannot sell that metal, and they lost profit on that damaged metal as well. Plus, they also claimed that because 15 hours there was no electricity, and in those 15 hours, we could have melted more metal and sell that. And because of no electricity, we didn't do that. So we lost profit on that as well. So they claimed for all three heads. Now, what did the judge said? The Court of Appeal held that Spartan could only recover the damages to their furnaces, the metal they had to discard, and the profit loss on discarded metal. They could not recover the profits lost due to the factory not being operational for 15 hours. Their main reasoning for this was that while the damage to the metal was physical damage and lost profit on the metal was directly consequential upon it, profit loss due to the blackout constituted pure economic loss. So the court said that okay, those person negligently damaged the cable, and because of that, your furnaces and your metal got damaged. Okay, they're fine. This is directly linked to their act, and the metal on which they were working. Now, if that metal got damaged, they could not sell that, right? So they lost profit on that metal as well. So this is also directly linked with the negligence of those contractors. So okay, you will get that as well, but you will not get the law. You will not get the profit loss due to the blackout. Why? Because that is pure economic loss. That is unconnected to the physical injury. Unconnected to the physical injury. So that will be pure economic loss, and pure economic loss is not recoverable. Okay, because it is unconnected to the physical injury. The metal was injured, physically injured because of the injury of the metal. You could not sell that, and you lost profit on that. Okay, so that is linked with that. The other metal which you haven't melted yet, okay, you cannot claim the loss for that. Why? Because that loss is a pure economic loss. Okay, so consequential economic loss is recoverable, or pure economic loss or financial loss is not recoverable. Okay, economic or financial loss anyway. Like for example, if in a road accident, you break an arm of a person due to the negligence. Okay, now that person, you will be entitled to pay him, for the damages that you did to his arm, like for example his expenses or hospital expenses and this stuff, right? But that person cannot put up the claim that, because you have break my arm, I cannot go to the office for 1 month, and I have lost my earning for 1 month. I lost my earning as well, plus I have to pay my bills as well, and I could not pay them because of your accident. So you have to compensate me all that. No, it does not work like that. Okay, those are pure economic losses. Consequential are the one that are related to the physical injury. Okay, directly related to the physical injury. And only consequential economic loss are recoverable in tort of negligence. Limits of duty of care. Now, what are the limits? There are 4 tests laid down in order to determine whether duty of care exists or not. Okay, so in order to determine whether a duty of care exists or not, you have to check all these 4 things. First, whether loss was foreseeable or not. Okay, whether the defendant could foresee the loss or not. If he could foresee that because of my action, other party can get harm, then only there was a duty of care, right? But he could not foresee the loss, then he do not owe any duty of care. Whether there was any neighborhood principle or sufficient proximity, right? Whether that person who suffered the damage was our neighbor, or whether there was any close relationship between my act and his psychiatric illness. Okay, whether he was secondary victim or not. Is it fair and reasonable to impose duty of care? Whether it is fair that the court will see that, whether it is fair that we should impose a duty of care in that situation or not. Okay, you have to see that as well. And the last one, whether there is any public policy existed that requires no duty of the care. Whether there was any public policy which was there that, which says that you do not owe any duty of the care. Like for example, if you go to a zoo, okay, and if someone fall, okay, if let's say if a person who is watching some animal, okay, like say he's watching lion, and incidentally he fall off in the lion's cage, or in the place where lion was held. Now, in the zoo, there was a notice mentioned that if something like that happened, no, common man should enter. No common man should enter the premises in which the animal is there. Okay. So now the thing is, if that notice was not mentioned, then there was a duty of the care, right? Because if you can save that person who has fell to, to the area where there was a dangerous animal in the zoo, then it is a duty of care to save him, right? But if in the zoo there was a notice mentioned that, you should not go yourself, you should call the authorities, then you do not owe duty of care. Okay. So these are the things that you will see while determining whether a duty of care exists or not. Okay. These are the limitations. Now, breach of the duty of care. So in order to be successful in the tort of negligence, the first thing is that you have to prove that you owe the duty of care from defendant. Okay. And who owe the duty of the care? We talked about that neighborhood principle, sufficient proximity in case of nervous shocks, and secondary victim, they owe the duty of care. Now, the second condition was there was a breach of duty of care. And the third one was that because of that breach, you suffered the loss. Now, we are going to talk about the breach of duty of care. Now, what does this mean? Now, this is very interesting. The claimant have to show that defendant was in breach of his duty, or he has not shown required standard of care. Very important point. Breach of the duty of care means two things. One, there was a duty of care that you owed to a person and you breached that. That is breach. Okay. Second one is that there was a duty of care to show some standard care, standard of care. Like for example, standard of care basically means that the duty of care that you owe to a person, there should be some standard of it, right? There should be some standard of that. That is on a standard of care. Okay. He has not shown a required standard of care. So if you have to show a required standard of care in some situation and you did not show that, you did show the care but not at that standard, then you also breach the duty. Okay. So there are two things in breach of duty of care. Number one, you breach the duty yourself, or you did not show the required standard of care. Now, what is the standard of care, and what standard of care, what degree of care we should show in different conditions? Let's talk about that. Standard of care usually revolves around the concept of a reasonable person standard. Okay. Whether someone acted with care as an average person would have in those conditions. Now, standard of care is basically that a standard, a degree of care that we expect from any average person at that situation. Okay. Standard of care means the degree of care that we expect from any average person in that situation. That is what he should show. That is known as standard of care. Okay. Now, standard of care varies with several factors. There are different factors that describe standard of care. Okay. Now, the first one is seriousness of injury. Degree of care required has to be balanced with the degree of risk. So greater risk of injury, the more should be standard of care. Very important. If you know that because of your act, okay, because of your act, other person can suffer serious injury, in that case, degree of care should be high. You required a high standard of care. Okay. So if the risk is more that other party can suffer injury, then you have to show more standard of care. Okay. Now there's a case in your book as well, Halley versus London Electricity Board, in which there was some maintenance work going on, and on side of the road. Okay. And because of that, they have to dug some hole. Now they covered the because of that, they dug hole, and obviously that was every the people, they were passing through that area. It was a regular area where people walk. So the place in which they dug a hole, they put up a notice board in front of it, that the maintenance work is going on, and there's a hole, so please be aware. Okay. So they put that notice so that area should be safe. Okay. However, what happened was that there was a person who could not see. There was a blind person who was, passing by that area, and he was not aware of that hole, right? Because the notice, only the person who can see, only the person who can see, they will be aware that there's a notice, so they will change the direction, right? But a person who is blind, he could not see the notice. So basically, the construction company, the company, they took the precautions, they took a right standard of care for people who can see, but for the people who could not see, they didn't. So the person who was blind, he fell off the cave, and unfortunately he became deaf as well. So he put up the claim on the company who was doing the maintenance work there, and he was successful. Why? The court said that that in this situation, the standard of care expected from you was high. Why? Because of the seriousness of the injury. You should have known that that a blind person is also traveling from this area. So you should have taken sufficient precautions. You should have covered the whole from all four sides. You should have covered that. So the blind person was going. He could feel that okay, there's some boundaries. I should change the direction, right? You did not show that. So when the seriousness of injury is more, you have to show high standard of care. The standard of care varies with the seriousness of injury. Greater the risk of the injury, more should be the standard of care. Okay. Age. Children are owed a high standard of care. If the person who can suffer from your act is a child, you should have high standard of care. You should show high standard of care. The adults, they the less standard of care is expected, but for children, high standard of care is expected. Now let's read a case here. A 7-year-old child died after eating a poisonous berry, and he had picked from the bush in the park controlled by defendant. The provision of warning. Okay, so there was very unfortunate case that a 7-year-old child, he eats some poisonous berries from the park, and when he eat that, he died basically. Now what happened was that his parents, they put up the claim. They sue the defendant who was controlling the park. Okay. Now what did the court said? The provision of warning notice was not enough. There was a warning notice there in the front of the bush that do not eat these berries, these are poisonous. Okay. But a 7-year-old child, he he will not he will not be he will not worry about that notice, right? Because the children, they they are innocent. They do not know the dangers of their act basically, right? So they owe high standard of care. So just putting up a warning notice was not enough. Okay. The court said that you should have covered that bush from four sides, so that no child could enter that area. You should have known that the children, they do not read the notices, or they did not follow the notices, because they are children, right? They are innocent. They do not worry about those stuff. So there was a standard of care shown by that person, by the person who was controlling the park, but it was not enough. Why? Because he should have known that a child also, visit the parks, and they owe high standard of care. So the standard of care shown should be high. Okay. Let's say if a 34 years old would have eaten the berry, then then he would not have been liable. Why? Because adults are owed less standard of care. The notice itself was enough. But in case of the children, the provision of the warning notice was not enough. Okay. Competency and skill. Standard of care increases with experience and possession of a particular skill. Very important point, that if you are possessing some skill, if a person is possessing some skill, he's an experience, then we will expect a high standard of care from him, right? Then we will expect a high standard of care from him. Okay. If let's say there's a person, if a doctor a 20 years old doctor will have a doctor with 20 years experience will be more competent and skillful than a doctor with 1 year experience, right? So standard of care also increases with the experience and possession of a particular skill. Now there's a case here. A doctor administered a spinal injection which had become contaminated as a result of minute cracks in the files. As a result of that, patient was paralyzed. Now try to understand this case. Now the injection, the injection bottles, they are very, very small, right? Injection bottles, they are like kind of very, very small. Now that injection bottle, there was a minute cracks in it. Minute cracks means that they were not visible by a naked eye. They were not visible by naked eye. So the injection bottles, small injection bottles, there were minute cracks in that injection, and those were not visible by a naked eye. So because there was some cracks, so the outside, the things were going inside the injection, so it become contaminated. And when the doctor, injected the patient, he got paralyzed. Okay, but here, no breach of the duty. Why? Because the doctor who had administered the injection had no way of detecting the contamination. Okay. Now try to understand that a doctor, you know, he had no way to detect whether the injection was contaminated or not, because the cracks, they were so minute that they were not visible by naked eye. So here he was not held responsible. Okay. If let's say the doctor knew that how to detect the contamination, then he could have held responsible. Okay. So this is what you need to understand, that uh, if the doctor here in this situation, he had no idea, he had no way how to detect the contamination. So if he had no idea, no way, then he is not liable. Okay. Hindsight is irrelevant. The degree of the skill is the standard required at the time of the tort. Hindsight means, uh the li- like for example, in this case, when the injection was injected and afterwards, the doctor found out that this was contaminated, then that thing is irrelevant. Okay. When the tort was committed, or before the tort, if he would have any idea of detecting the contamination and he did not do that, then he will be liable. But if he had no way of detecting the contamination and afterwards it was found out, then he is not liable. Okay. So hindsight is irrelevant. Hindsight means understanding the situation after that act happened. Okay. Lack of skill. Lack of training is not relevant. Standard of the skill expected from a trainee driver will be same as applied to normal drivers. Lack of training is not relevant. Standard of the skill expected from the trainee driver will be same as applied to the normal drivers. Okay. Now let's read a case here. During a driving lesson, the defendant, who was a learner driver, lost control of the car and caused an accident in which the claimant was injured. The defendant argued that the claimant was well aware of her lack of skill, and the court should make allowance for her, since she could not be expected to drive like an experienced motorist. Okay. So what happened was, there was a trainee driver who was driving, and while she was driving, she lost the control of the car and caused an accident. Because of that accident, the claimant got injured. Okay. And when the claimant put up the case against, or sued that lady, who was trainee driver, the lady put up an excuse that I am a trainee driver. So you should not expect standard of care from me as of an experienced driver. But in such situations, the law says, because the degree of risk is high in this case, like if someone is driving on a road, any person, he can cause severe injuries, right? So in that situation, lack of skill cannot be used as an excuse. Lack of skill is not used as an excuse. You cannot use that. If you are driving on the road, we will expect the same standard from you as we would expect from any other normal driver. You cannot use this as an excuse. Okay. So she had to pay the compensation. Cost and practicability. Okay. If the cost of the safety measures is high, then standard of care is determined after considering the cost benefit analysis. Now, basically, let's say that because of your act, the person, you can foresee a harm. Okay. Now, the thing is, how much you can save the harm. Okay. Now, if to preventing the harm cost is too high, if for preventing the harm the cost is too high, then in that case, the standard of care is considered after determining the cost benefit analysis. Okay. Now let's understand this with this case. A factory was flooded as a result of a heavy rainstorm, and as a result, made the floor very slippery. The defendant, who owned the factory, arranged the sawdust to be spread on the floor. So there was a factory, because of the flood entering the factory premises. The factory floor becomes slippery, and factory is now slippery. So it means anyone can get slip and can get injured. So the owner, a duty of care to everyone who is in the factory, right? Now, what happened was that owner arranged the sawdust, so he could spread the sawdust on the floor, so the floor will not be slippery. Okay. Now he put up a sawdust on the floor. However, there was insufficient sawdust to cover the whole area. Now the sawdust that he purchased, it was insufficient. Okay. The claimant slipped and injured himself. So now try to understand the case. Let's say this is the factory. Okay. Now let's say this is a factory, and let's say these are the areas in which the people do not commonly enter. This is the area which is largely used by the factory workers. They move around this area. Okay. Now what happened was the flood entered into the factory. Okay. Now the employer, who was an owner, he he put up the sawdust on all of that area where he could foresee that the people or the workers, they walk in this area. So he put up the sawdust so that workers could not get slipped and injured. But there was a worker who entered this place where normally the workers do not enter, and sawdust was not put up there, so he slipped and he got injured. And when he got injured, he put up the claim on his employer. Okay. But the court said that the employer, the defendant, is not in breach of his duty to take care, as he had taken all the reasonable precautions that was expected in that case. Okay. As far as it was practicable, the thing was that putting up the sawdust on a whole of the area was very expensive, right? So the reasonable measure he took was that he put up the sawdust on that area where the workers were regularly moving and walking, and they were doing work, because that was the area where movement is more, right? So though that area is more prone to the risk. So the employer he took the reasonable standard of care and put up the sawdust on that area. Now the worker who entered that area where normally the workers do not enter and get himself slipped, then he is liable himself, right? The employer did take the reasonable harm. He could not put up the sawdust on the whole of the factory because it's a huge area. He put up the sawdust on those areas which were regularly used. So he did take his reasonable care of he did take care reasonable precautionary measures as far as was practicable to eliminate the risk. Okay. So he was not held liable. If a person acts according to common practices of society, standard of care is assumed to be satisfied. However, if common practice itself is negligent, then this rule will not apply. Okay. Now, there's a common practice in an area, like let's say, for example, there's a common practice that now there are two types of the helmet, right? The ones that motorbike people, they put up the helmet, and the construction workers, they put up the helmet which do not cover the face, right? Now there's a common practice in an area that the motorcyclists, they use those helmet in which the face is not covered. Okay. That is a common practice. And because of that, okay, let's say there's a delivery there's a delivery company, they're responsible for delivering food to the customers. Now they are giving that helmet in which the face is not covered, and they gave this helmet to their workers, delivery drivers. And one delivery driver, he was when delivering the good, he got injured. There was an accident, and because of that, he suffered injuries on his face. Okay. Now if he will go and put up the claim on the court that that my employer was negligent, they did not provide me with the helmet that would cover the full face as well, so they are entitled to compensate me. Now in that case, the employer can use this as a defense that this is a common practice. Everyone in this area use the helmet in which the front face is not the face is not covered. It's a common practice. So in that case, the common practice will work. So the standard of care will assume to be one that is in common practice. But if the common practice itself is negligent, then this rule will not apply. But if the common practice, itself is negligent, the rule will not apply. Like for example, if you are doing, let's say, some welding work and some metal work, in that case you should wear goggles, right? You should wear glasses, because any nut and bolt can enter your eyes, and your eyes can tap you can suffer the loss of eye, right? So that is why if that practice is itself is negligent, then in that case this rule will not apply. Okay. Now there was a case in your book as well, in which there was a person who was doing garage mechanic work, and he only had one eye. He lost the other eye in the wartime. Okay. Now what happened was he was trying to loosening a bolt, and when he struck the bolt with hammer, the bolt it flew off and entered his other eye. Now he haven't wear the goggles, so the bolt hit his another eye, and he lost his both eyes as well. So he was not completely blind. Okay. Now uh the what did the court said? The court said that okay, that was a common practice in that case. Okay. That is a common practice to do the work in a mechanic shop, in a garage shop, without without the glasses. Okay. That's a common practice, fair enough. But this person who already has lost his eye, the risk of injury is high. So we expect high standard of care. We expect high standard of care from the employer. He should have provided him with the goggles, because he has already lost his one eye. So risk of injury is more. risk of injury is more. So the high standard of care should be expected. Okay. So this is what you need to understand in the standard of care. That if a person is more prone to injury, like for example, if a person is disabled, it is likely that he will get more serious injury. So he owe more duty of the care, high duty of the care from the defendant. Okay. So this is the standard of care. Okay. So there were three things that you need uh, to establish. There are three things that you need to establish if you want to be successful, or three things or three conditions it should be met, it should be proved by the claimant in order to be successful for the tort of negligence. First one was that defendant owed duty of care, which we talked about, that the defendant owed duty of care if other person is his neighbor, if other person can suffer nervous shock because of his action and he's in the sufficient proximity, and if the other person is secondary victim. Okay. Then we talked about that the defendant breached their duty. Defendant breached the duty. And what do the breach mean? Breach means either breaching the duty or either not showing the required standard of care. Okay. That is also a breach of duty of care. Okay. And the third point was that because of that breach of the duty, the claimant suffered the loss. Now let's talk about the third point, third condition, causation. Loss caused by breach. Claimant must demonstrate that he has suffered loss or damage as a direct consequence of breach. This is also known as but-for test. Okay, but-for test. Now, the third thing that claimant should prove, that because of the breach of the defendant, I suffered the damage. Okay, that is known as causation. That your breach resulted in my loss. Okay. Now, claimant must establish a causal link between defendant's conduct and damage which occurred. Okay. So you have to link the defendant's act with the damage that you suffered. If damage was caused by someone or something else, there will be no liability on defendant's part. A very interesting point. Let's say you committed some tort, but because of that, the other party did not suffer the damage. Okay. The damage was caused by something else. Then, even if you did the tort, the damage was not because of your tort, you are not liable. Okay. You are not liable. It is a very interesting point. Okay. Let's say, for example, uh, uh, if let's say I gave you an example of the sawdust, that if, for example, you did not put up the sawdust on the wet slippery floor, and the claimant, he did not suffer he slipped, but he did not suffer any damage. Okay. Then in that case you are not liable, because if he had suffered some damage, some physical injury, some damage, then you will be liable. Okay. So the third condition does not mean so you are not liable. So first point is, if damage was caused by someone or something else, then you are not liable for that. Okay. Other point, if claimant would have suffered the loss regardless of your conduct, then he has not caused a loss. If claimant would have suffered loss regardless of defendant's conduct, then he has not caused the loss. So it means that defendant has not caused the loss. Okay. Now, what does this point mean? Let's understand this point from this case. So second point basically means, the claimant would have suffered the loss regardless of, what you did or what you did not. The claimant would have suffered the loss regardless of what you did or not. Then you are not liable for that loss. Okay. Now let's understand this with this case. The claimant's husband, Mr. Barnett, went to the hospital complaining of severe stomach pains and vomiting. He was seen by a nurse who telephoned the doctor on the duty. Doctor told her to send him home and contact his general physician in the morning. Mr. Barnett died 5 hours later from the arsenic poisoning. Now, try to understand this case. So, the claimant's husband went to the hospital. He said that I am having severe stomach pains, and I am having a vomit on the night time. The nurse who was on the duty, he called the doctor, who was at that time. So the doctor, he said to the nurse that ask the patient to go home and contact his general physician in the morning. Now Mr. Barnett died 5 hours later. After 5 hours, Mr. Barnett died. Even if the doctor had examined Mr. Barnett at the time, there was nothing the doctor could have done to save him. Therefore, the hospital was not liable, as the doctor's failure to examine did not cause his death. Now, the thing was that now we have to establish a causation, that because of the doctor's failure to examine the patient at the night, patient died. If this is it, then the hospital is liable. If this is not, then the hospital is not liable. So what from the report, from the postmortem report, it was found out that the Mr. Barnett had a poisoning. And even if the doctor at that time would have saw Mr. Barnett poisoning was so severe that he would have died, in any case. He would have died in any case. So that is why the hospital was not held liable. Why? Because, claimant would have died regardless of the defendant conduct. Regardless of the defendant conduct, then, the defendant is not liable for that. So that is the causation test. Then comes vicarious liability. It occurs when one person is held responsible for negligence of other. When one person is held responsible for negligence of other, that is known as vicarious liability. And vicarious liability typically comes in the employment context, like the case we studied, in which that if the doctor is negligent, hospital can help liable. That is vicarious liability. That if employee is negligent, then employer can held liable for negligence as well. When where the employer is responsible for the negligent acts of employee which occurs within the context of employment. So if any employee does an act during the course of his employment, during the course of his work, then the employer can be held liable for that act of employee. Okay, that is known as a vicarious liability, that you can held employer liable vicariously. Okay, now there's a case here. A school board employed a warden to manage boarding house for vulnerable children. Okay, vulnerable children means, the children, uh, obviously the orphans and the ones, who ran away from the house. You know, they face harsh things in childhood. So the vulnerable and the one vulnerable means, those ones obviously, who are orphans, who have witnesses the harsh things in their lives. Okay, the warden committed sexual abuse of the children. The claimants, the abused children, sued the school board for vicarious liability. So the warden was involved in the abuse of the children. The abused children, they, instead of suing the warden, they sued the school board, okay, for vicarious liability, because it was their job to manage the warden, right? The court overruled the earlier decision to hold the school was vicariously liable. The first court said that, the school board is not liable, but they overruled that. Why? They said that the act committed by the wardens were during his time of employment, right? During his time of employment, these acts had been committed on the premises and during the time when the warden should have been complying with his duty of the care for the children. The connection of the time and place and the inextricable link between the acts of the abuse and the employment were sufficiently close to establish a liability. So this is what the judge said, that, he was in his course of his employment. It was the school board's duty to oversee him, and it was the warden duty to take duty of the care. And school board have employed the warden, and they did not, uh, took the sufficient actions, or did not, try to look at what warden is doing. So because the warden did all these abuses in the school during the course of an employment, so the employer, who was a school board, can be held liable for the act of wardens. Okay, they can be held vicariously liable.